Hello, everybody. My name is TJ Scott or Timothy Scott. I'm an estate planning attorney with the Law Office of Timothy J. Scott, and I'm very happy to have you here with me today. We're going to be talking about something that I know is difficult to think about. It's difficult to talk about. What happens when you die? What happens if you become incapacitated before you die? I know those are difficult things to contemplate, but I also believe that knowledge is power. And that's what I want to give you today. I want to empower you with knowledge and information about this topic so that you don't have to be afraid of it anymore. Today, I have some really valuable information I want to share with you. And I also have some valuable offers that I'm going to make at the end. So I hope that you'll stick with me through the entire hour. I hope that you'll ask questions as questions come up. And I will be keeping an eye on the chat and the Q&A box for those questions. Nobody's shared where they're joining from, but I'd appreciate it if you would. I'm curious to find out where you're joining from. So if you can find the chat button and type in where you're joining me from, I'd really appreciate it. All right, the best way to learn here today is to turn off the distractions. If you have another window open, if you have Hulu on or Netflix on, I probably shouldn't be saying brand name things right now, but I encourage you to give yourself this time that you've set aside to learn about estate planning. There's a ton of information here that I'm going to share with you tonight, and it can be difficult to keep up. It's complex. The laws are just complex in this area, but I promise you that you will be very thankful. Your future self will thank your current self that you devoted yourself and you devoted the time to learn about this topic and to get this information. Chat is disabled. Well, that's not done on purpose. I don't know why that's happening, but I'm glad that you're letting me know. It looks like you may just have to use the Q&A in order to talk with me. Can everyone see this? So I just put a message into chat, and maybe that helps to unlock something. I'm not sure why we would be having issues. I see somebody's joining from St. Paul. That's fantastic. My family I live with my family here in Bloomington, but we recently came to Bloomington from St. Paul and completely love the area. Why on earth would we have issues with you know what? I'm just not going to be able to figure it out, and that's okay. We're just going to keep moving so that we don't get bogged down in this kind of thing. So if you have any questions, feel free to share in the Q&A. And not sure why the chat would be disabled, but I appreciate you letting me know that. And attendees can chat with everyone there. Maybe now chat will work. I hope that fixed that. All right, sorry to get bogged down in that. Technical issues sometimes raise their terrible heads. I see somebody saying, yes, Missy, thank you for sharing. And it's good to see you here in the chat. Fantastic. Good. All right, so if you stick around until the end, I have a couple of offers that I want to make to you. First is a free virtual one-to-one meeting with me. There's no obligation in that meeting, but we'll be able to talk about exactly what you can do to protect the things that you have and the people that you love and put a plan in place to get them taken care of. Plus, I have a bonus gift that's going to make it even easier to get a custom tailored estate plan done for you. Just stick with me here till the end. I promise it's coming. All right. So the first question that I have for everybody, and I actually have a poll that goes along with this. Hopefully we won't have any issues with the poll sharing out. But the question is, do you have an estate plan? And a lot of times people ask, or I ask people, do you have an estate plan? Have you done estate planning? And they'll say, well, what does that mean? Does that mean a will? Maybe, often it includes a will. But an estate plan is a lot more than just a will as well. Sometimes it includes a trust. Sometimes it includes guardianship nominations if you have minor kids. Often it includes incapacity planning documents as well. In fact, I think that those are pretty crucial. Things like a healthcare directive, power of attorney, and then making sure that you have beneficiary designations set correctly with things like your 401k and life insurance. And I see somebody's joining from Brooklyn Park. Fantastic. Thanks for being here tonight. And I am seeing more no's than yeses, which is not uncommon to hear that. So don't feel like you're in a bad place. In fact, if you don't have an estate plan in place, you're here in the right place tonight to talk about that and to talk about how we can get that addressed and how we can get that fixed. All right. Next poll that I have for you, if you don't have an estate plan in place, why not? And maybe one of these things resonates with you. Maybe you are too busy. Yeah, and if that's the case, I totally get it. I am a father of 4, and I have my own business. I am very busy and I get running from thing to thing all the time. But I want to say, if you felt too busy in the past and you've dedicated yourself to being here for an hour tonight, I want to give you a pat on the back, because that's something that's really fantastic. And to take the time aside and to start this process, it's great that you're taking the first step. Maybe you feel like you're too young, and I see somebody saying that they feel too young to need an estate plan. But the truth is, anyone over the age of 18 really should have some kind of estate plan in place. I recently helped out a young family where a father had passed away and left something of a mess for his wife and minor daughters. But it didn't have to be that way. You can get an estate plan in place, and you can get things done even from an early age. An estate plan that will grow with you, and that can be adjusted in minor ways as you get older. And I see a lot of people saying, or I see some people saying, that they're worried that it's too expensive. I completely get that. And before word processing, estate planning truly was just for the wealthy or just for the rich. But nowadays, estate planning is for everybody. We have word processors. It's more accessible than it's ever been. And again, I hope that you'll stay with me until the end, so that you can see my bonus offers to make it even more affordable. I don't see anybody saying that they're worried about jinxing themselves. I've had it in the past, though, and I understand it. But I can tell you, of the dozens or hundreds of estate plans that I've written, I've never seen a correlation between getting an estate plan done and having something negative happen in somebody's life. There's just not a correlation. In fact, I like to say, I think that my clients tend to live a more intentional life, or they have this weight that's lifted off of their shoulders. So I think that there's less of a chance of something happening after they get an estate plan done. So thanks for sharing, everybody, in that poll. The next question that I have for you is, if you have an estate plan in place, or if something on this just resonates with you, what is it that you're hoping to learn here tonight? And maybe you've done an online will, or maybe you're considering doing an online or do-it-yourself will, and you want to know if it's okay, if it's going to take care of your family in the way that you want your family to be taken care of. Or maybe you did a plan, but it was 20 years ago and you had minor kids at the time, and now you're worried that they're going to have to go live with a guardian somewhere after you pass away. All right, that's probably not what you're concerned about, but you're wondering, is it outdated? I did this plan 20 years ago. I did this plan 10 years ago. Is it outdated? How do plans get outdated, and how often do they need to be updated? We'll talk about that a little bit tonight. Maybe you just want to have a better understanding of estate planning and exactly what goes into it and what it means, and how you can get an estate plan in place. And I encourage anybody who has specific questions that they want answered tonight, I encourage you to either put them in the chat or put them in the Q&A, and I'll make sure to get to them, and I'll make sure to answer those questions for you. Thanks, everybody, for entering into these polls and sharing your information with me. I really appreciate it. I want you to know that you're in the right place here tonight. You're in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you did an online or fill in the blank will, or you're considering doing an online or fill in the blank will, but you're not sure if it's going to take care of your family the way that you want them taken care of. And you're in the right place if you're nervous about how much this is going to cost. I'm going to address that tonight. I'm going to talk about exactly what expenses you can expect for something like an online will, what expenses you can expect for something like a traditional estate planning attorney, and exactly what expenses you can expect working with an attorney like me, who's going to custom tailor an estate plan that is designed specifically for you. I'm going to talk about all those things here tonight and give you some peace, especially on that point. The reality is that estate planning isn't about us. And this is something that my wife and I talked about recently while we were updating our estate plan. It wasn't going to enrich us. It's not like a small business, or it's not like an investment that is going to compound and grow over time. It doesn't function that way exactly. But it's really a gift that you're giving to the people that you love. You're getting stuff sorted out. You're getting your affairs in order in your lifetime, so that they don't have to sort through things and get things in order after you're gone. And your loved ones are really going to know after you've passed whether you've lived up to your promise to take care of it. So here are the things that we're going to cover today. We're going to cover talking about planning for incapacity. We're going to talk about planning for who can make healthcare decisions for you if you can't make them for yourself, who can make financial decisions for you if you can't make them. I'm going to share one final poll here. It's a demographics type poll. And what I want to hear here, what I want to see here is how many people have young kids, because guardianship is an issue that really only applies to people with minor children. And if we don't have a lot of people here with minor children, I'll spend a little bit less time talking about that. But if we have more people here with minor children, I might take a little bit of extra time just to really emphasize the things that you need to have in place for minor kids. But planning for passing away, we'll also talk about probate. We'll talk about that court case called probate and the time, cost, and public nature of it. We'll also talk about how it can be avoided in a really bulletproof and clear way. We're going to talk about estate taxes tonight, and there I get to give most people good news in talking about estate taxes. We'll talk about unclaimed property and what that is and how property becomes unclaimed or goes to the State Department of Unclaimed Property. And we'll talk about intangible assets, things like your stories and your values, and how you can hand those stories and values on to the people that you love after you're gone. So I see some people with young kids here tonight. But it looks like most people either have grown kids or don't have any kids at all. So again, I really appreciate you sharing with me. I will spend a little bit of time talking about guardianship, but we'll move pretty quickly through it so that we can address more conversation about the assets and about incapacity planning, which really applies to everybody here, okay? But before I jump into that, I just want to share a little bit about me, the guy who's going to be talking to you here for the next 45 minutes or so. This is my family. As I said before, we live in Bloomington, Minnesota. My wife's name is Tobin, and we have 4 kids now. We have Ben, who's right in front of me there. Ben is 10. Elizabeth is 7. Margaret is 5. And little baby Bridget is just 4 months old now. But my family is really my whole world. It's where I spend my time and where I really spend my energy, where I love to spend my energy. So I graduated from the University of St. Thomas School of Law in 2012, near the top of my class. And the very next day, my son was born. So now you know how long I've been practicing law for. But there he is. That's Ben, holding him on the day of his birth, May 13, 2012. After law school, I found a job with a small estate planning and tax preparation law firm. And I love the clients that I was able to work with. I love the work that we were able to do for them. At the same time, I didn't always feel like we were providing the value that my clients deserved. And so after a little more than 3 years with them, I actually left that law firm. And this is a picture of my last day there at that small law firm. All right. A little slow to respond. There we go. Someone has to graduate at the bottom of the class. Now, I just want to say off the top here, this was not said about me. This was said, actually, it was something that my parents said about an extremely negative experience they had working with an estate planning attorney who helped my grandmother. And I remember my mom saying, someone has to graduate at the bottom of the class, in reference to this attorney, figuring it must be a deficit of knowledge, it must be a deficit of intelligence or something like that. But I don't actually think it was this attorney's knowledge. I think this attorney was practicing under a faulty model. I call it planning for death. And I'm going to talk a little bit about that later. But first, let's get into some of the aspects of estate planning. And we are going to start with that important thing for parents with minor children, talking about guardianship. And so I understand not everybody here has minor kids, but I think we all know somebody who does have minor kids. And this is really important information to share with them. There are a couple of types of guardianship that I want to talk about. And the first is short-term guardianship. And short-term guardianship, the way to think about that is, what happens if you're out on a date and something happens? The kids are home with the babysitter and you don't come home. And the clock ticks on, it's midnight, 1 o'clock, 2 o'clock. At some point, without a plan in place, without a clear direction to the babysitter, that babysitter is going to pick up the phone and call the police and say, Mom and Dad never came home. What do I do with these kids? And the police are going to come to the house, they're going to show up, and most likely Child Protective Services is going to be called, and they're going to take the kids for some amount of time. And this isn't to rag on Child Protective Services. I think that they do the best that they can with what they have. But I can tell you, as the father of 4 minor kids, I never want my kids to spend a moment with Child Protective Services. It's not a good environment for them. I know it's not. And so it's very important for me that I have short-term guardianship plans in place, not just documentation about exactly what the babysitter should be doing, but also documentation that shows legally that the people that I love, the people that I trust, can stay with my kids, and that Child Protective Services doesn't have to be called because they have the clear legal right to stay with the kids. So that's short-term guardianship. Long-term guardianship is who can raise your kids until the age of 18. And if you don't have a plan in place, the truth is that there is a plan out there. And that plan is that a judge is going to decide what is going to happen to your kids. And unfortunately, it's probably a plan that you're not going to like, right? Because you know where your kids would flourish. You know who would best raise them until the age of 18. It might not be who the judge would think is the best person. You know, if Uncle Larry looks good on paper, he has a job, he has a home, everything looks good on paper, but you know Uncle Larry is the last place that your kids should go. Unfortunately, if he looks good on paper, a judge might decide Uncle Larry's the person to take the kids. And that's something that you want to get in front of. You want to get documented so that you get to decide where the kids are going to go, where they're going to flourish, and the person who's going to raise them until the age of 18 in the way that you would want them raised and taken care of. Now let's talk about the assets. How would the kids receive the assets? How would whoever the person that you love or the people that you love receive the assets after you're gone? And again, if you don't have an estate plan in place, or if you have done an estate plan, but you've planned with a will, then there is an estate plan in place for you. And that estate plan is called a court process called probate. A lot of people are surprised to hear that even if you have a will-based estate plan, that probate is necessary. But unfortunately, it is. Probate is the process where the court will actually interpret your will and make sure that the provisions of your will are carried out. And so if there's we have this terrible, goofy saying in the estate planning world, where there's a will, there's a probate. And it's, man, it makes me cringe every time I say it, but I say it all the time. And so where there's a will, there's a probate. If you're relying on a will to pass your assets to somebody else, that will is going to have to go through the probate process, is going to have to go through the courts in order to be effective. And the same thing, if you don't have a plan in place, again, there's a plan that's written for you. The state writes this plan for all of us based on what they think you would want to have happen. And there are certain statutes called intestacy statutes that say exactly who your personal representative should be, who should receive your assets if something happens to you. For a lot of people, it makes sense. It's spouse, it's kids. It's if it can't find somebody in your spouse, kids, grandkids line, then it goes up to your parents' line and looks at brothers and sisters and their kids. So it makes sense. It's following this family trajectory. Makes sense for a lot of people, but it doesn't make sense for everybody. And so if that's something, if you want to change who would receive under your plan, if you have the state's plan, but you know that a brother or sister or niece or nephew would receive, and that's the last person that you would want to have receive your assets, then you really need to get a document in place. Even a will is better than just having them received by default through the intestacy statutes. But let me talk a little bit more about this court process called probate. Probate is a process that you have to go through the county court in order to have somebody step into your shoes and be able to deal with your assets and deal with your creditors. And a few things about it, it takes a really long time here in Minnesota. It's slow. It takes a minimum of 6 to 12 months. More often, we're seeing something like 12 to 18 months. I recently contacted a county courthouse, and if I filed today, in August, a probate case, they said the earliest they would hear my probate case would be November. That's totally crazy. There's no reason for that other than the courts get bogged down, they get busy, it's difficult to hear as many cases as are coming before them, but it is really slow. And it's not just slow to be heard initially, but it's a slow process intentionally. that really it's a process for your creditors to come forward and get paid from your estate, whatever they're due. And so there are built-in slowdowns for your creditors to come forward, for the Department of Human Services to make a claim if you've ever received medical assistance in your life. There are all these built-in slowdowns in order to make the process drag out before distributions can happen. And that can be really harmful when you just want your assets to go to somebody, but now they have to sit and they have to wait for 6 months, 12 months, 18 months in order to actually receive a distribution. It can be really painful for them to have to wait that length of time. Probate's also costly. There are all kinds of fees built into it: attorney's fees, executors' fees, appraisers' fees. And we have kind of a back of the envelope way of estimating what your probate might cost. And we estimate that in Minnesota, probate costs something like 3 to 6% of the gross value of your estate. So you can imagine if you own a house that's worth $400,000, and that's a pretty nice house for a lot of people, but nowadays it's more and more realistic, a $400,000 house. 3 to 6% of that $400,000 house, keeping in mind we're talking about the gross, so that's just the fair market value. We're not talking about what equity you have in the house, but that $400,000 house, in order to get that through the probate process, we're talking fees between $12,000 and $24,000. Once you tally in attorney's fees, it can get even higher than that with all of the delays and all of the time that it takes in order to move the house through. If you're paying a mortgage and utilities on that house at the same time that you're going through the probate process, it can get extraordinarily expensive. So 3 to 6% is kind of a, like I say, back of the envelope math. But we'll actually have a chance to calculate what your probate might cost here in just a little bit. Probate is also public. And so here's the last will and testament of Anna Nicole Smith. And I was able to get this because it had to be filed publicly with the court. And the court believes in transparency, believes in opening things up so that anybody can inspect exactly what's going on and what's happening in any specific court case. There are times when they seal documents if there's a social security number on it, or if it has a financial, if it's a bank account number or something like that. But other than that, things are just public. And so there are inventories that have to be filed. There are final accountings and distribution plans that have to be filed. We all know that there are, unfortunately, some bad people out there who might use that information to prey on your heirs who would receive a distribution if that information is made public and they're made aware of that information. For those of you with minor kids, and there's only a few of you here tonight, but if you have minor kids and you pass away, then those minor kids stand to receive the assets at the age of 18 and completely unprotected. And I can tell you, I like to think I was a pretty mature 18-year-old. There's actually somebody here who knew me when I was 18 and when I was younger than 18. I don't know what she would say, but I can tell you, if I had received a bunch of money at the age of 18, I would have gone out and I would have bought a Corvette and I would have driven it really, really fast, because that's where my head was at when I was 18 years old. And so unfortunately, 18-year-olds just shouldn't be trusted with a bunch of money. It's just a fact of life that that's not something that we should be trusting them with. We should be protecting them from the money, really, so that they can enjoy it at a time when they have more sense about how to deal with it. All right. So here we have a chance to actually calculate your probate estate. And when we calculate the things that go through probate, your probate estate, the things that we're talking about are things that aren't passing by beneficiary designation generally, okay? So life insurance generally passes by beneficiary designation. Retirement accounts generally pass by beneficiary designation. Oftentimes, if you're married, you'll own the family home in joint tenancy. And so when just one spouse passes away, it will automatically transfer to the other spouse. But if both of you pass away, or if you're single, then that family home has to go through the probate process in order to get to whoever your heirs are, whoever is going to ultimately receive that property. So here you can see we have a family home, we have a rental property, we have some furniture and household goods. We have some automobiles, stocks, bonds, and bank accounts, business interests. All of these things generally don't pass by beneficiary designation. They have to go through the probate process ultimately, like I say, maybe it's when husband and wife pass away, or maybe if it's a single person, just when the single person passes away. But you can get 5% of that total number by moving the comma over one place. So that's 85,000, and then cutting that number in half. And that's how I got $42,500 in estimated probate costs and fees. And that doesn't function like a tax. That's not an amount that the court actually collects from you, but that's an amount that has to go to pay attorney's fees and personal representatives fees, costs of maintaining property throughout the probate. All of these different things, appraisal fees, all of these different things add up to about that 3 to 6%. So you're able to calculate here what it might cost for you to go through the probate process, or what it might cost your assets to go through the probate process. And just to add a little wrinkle to this, if you have life insurance or retirement accounts that are payable to a minor, you want your kids to receive, but they're not of the age of 18, then there's an alternate procedure that they have to go through called conservatorship, which is very similar to probate and requires actually an ongoing reporting with the court year after year until they're actually the age of 18 and they can actually receive the assets. But you can see here, life insurance, retirement accounts, those generally would pass by beneficiary designations and avoid probate. But unfortunately, if they're payable to a minor, they end up being a part of the probate and really can increase the cost of probate pretty substantially. But the fantastic news is there's a bulletproof, foolproof way to avoid probate, and that's by writing what's called a living trust and fully funding that living trust. And let me just tell you what that means. The simplest form of a living trust or a revocable trust in general, is for one person to give property to another person and say, these are the rules that I want you to follow with that property. That property is still mine, but I want you to deal with it, and these are the rules that I want you to follow. And to have this other person say, yes, I agree to follow the rules that you just laid out for me. That's what a trust is. It's an agreement between these two parties, the party that starts with the property, and then the party who's going to control the property. That's what a trust is, okay? And we write that down. Obviously, we want it written down so that everybody knows exactly what the rules are and the trustee knows what they are guaranteeing. With a living trust or a revocable trust, it's a little unique in that you are both the person starting with the property and you're handing the property over to yourself in a separate role as a trustee. It's like you're wearing another hat. So you're handing the property from yourself to yourself, wearing another hat in this trustee fiduciary role. And you're saying, I need you to follow these rules, and you're promising yourself, yes, I'll follow those rules. That's what happens during your lifetime. The beauty of a living trust is when you die, that you can have a successor trustee step into your shoes. They already have that property that's already in the name of the trust, and they're able to deal with that property without having to go through the probate court and having to deal with the whole circus and all the costs and expenses and time that the probate court takes. But it's very important that you have this handoff of property, that you make sure that you hand off the property to your trustee. And what that means is something different for each type of property. So for investment accounts and bank accounts, it's retitling those investment accounts and bank accounts in the name of the trust. And for a bank, that means taking a trip to the bank and signing new signature cards so that now that bank account is actually in the name of the trust. For real property, things like your home and rental property, means executing a deed to real property so that that property actually transfers into your name as trustee of your living trust. Excuse me. For stocks and bond certificates, it means transferring those stock and bond certificates again into the trust, assigning personal property. That can be done either with an assignment of personal property. So personal property is things like furniture, clothing, jewelry, firearms, tools. All of these things are personal property. They're not titled with the state. They're just the type of personal property that you have all around you. And those go into your trust by signing something called an assignment of personal property or a bill of sale. And that's what transfers that personal property into the trust. And then life insurance and retirement accounts, Those have beneficiary designations on them so that you don't want to transfer those over during your lifetime, but when you die, you point those over so that they end up with the trustee of your trust, and your trustee is able to deal with those life insurance proceeds and retirement accounts after you are gone. This is really a foolproof way of avoiding probate, but it is key that you fully fund that living trust. And that's something that I help my clients with because it's so important to get this aspect right in order to avoid probate, which is what many of us want to do. It's what benefits most of us. All right, here I get to give everybody some good news. I haven't seen a single question come through. It doesn't look like at this point. So make sure if you have questions that you are brave enough to ask them. Remember, if you have a question, it's likely that a number of people also have the same question and are just waiting for you specifically to ask that question. I don't know if that's true, but estate taxes, I get to give everybody some good news. There is an estate tax on the Minnesota level and on the federal level. And I believe that somebody was joining us from California. Unfortunately, I don't know. I am confident that California has an estate tax, but I don't know exactly what their exemption amount is. But I can tell you on the federal level, you don't have to start paying a dime of estate tax until your estate is valued at more than $12.06 million. Once your estate is that high, you might start paying at up to 40% or 40 cents on the dollar for everything above that amount. But you actually get to double that amount if you're married, which is kind of fantastic. In Minnesota, we also have an estate tax, and that estate tax rate is somewhere between 13 and 16%, but it doesn't kick in until you reach $3 million. We have a $3 million exemption, and that $3 million exemption can also be doubled with some estate planning in place if you're married. If you're married, you can double that amount. I see somebody asking here, how will any fees from a trust be less than probate fees? That's a fantastic question. It just is less money. You don't have to go through the court process with a trust. You're able to have that successor trustee step into your shoes. And there is a process that often happens called trust administration. Well, there's a process that has to happen called trust administration. Sometimes your trustee will want an attorney to guide them through and to make sure that they're following the rules of the trust and that they're following the rules of the state in the correct way. But it's not as necessary that they hire an attorney as it would be if they were in court and going through the probate process. So having a trust, having trust administration is significantly less expensive, takes much less time. You can have everything resolved in a month, 2 months after the person has passed away with the trust. Whereas with the probate, you're likely to still be in the probate court a year after you've opened that probate. So good question, but it is it's just a totally different world having a trust as opposed to having a will going through probate. So hopefully I put everybody's mind at ease regarding estate taxes. But if you have an estate that is valued at more than $3 million, or if you are building assets and you believe that you'll soon have an estate worth more than $3 million, I certainly hope that you'll reach out to me. It's not the principal reason that people are doing estate planning right now. There are many other good reasons to do estate planning, including avoiding probate, making sure that you have the right person in place for your kids in a guardianship situation, right? Ensuring you have the right person in place to take care of your healthcare decisions and financial decisions if you need all those things. Can you go back a slide or two where you include life insurance and retirement added to the cost of the fees of probate? Why do those get added to probate? Fantastic question. So in this question, I'm just going to back up really quick and address this. These are life insurance and retirement accounts payable to a minor. And the reason that we've added those in to calculating the probate estate is because when they're payable to a minor, they have to go through a process called conservatorship, which is very similar to probate, very expensive, and also has an ongoing reporting element. So fantastic questions. I'm happy to answer them. And again, if you have the questions, it's likely that someone else has the questions too. So good. Will your assets be lost to the state? So does anyone have any idea how much money is currently in the Minnesota State Department of Unclaimed Property? And I'm not going to keep you waiting. Something like $700 million And across the United States, that number is something like $53 billion. And a big part of the way that that money gets there is when somebody passes away, their heirs, their fiduciaries, the people who are supposed to be collecting everything and finding everything, aren't aware of all of the accounts, of all of the stock ownership. They're not aware of all of the finances of the person who's passed away, and something gets missed. And this is especially prevalent and especially concerning today when we have electronic statements turned on. So many of us have electronic statements turned on, and the statements aren't coming to the house in the mail anymore, where the personal representative or where the trustee or whoever it is can find that information easily. Or if you have money in Robinhood or Coinbase or something like that, that money can be really difficult to find if something happens to you. And so something that is crucial that I help my clients with, and that I strongly encourage, is keeping an inventory of your assets somewhere, so that your heirs and the people that you love will know and be able to collect everything if something happens to you and when something happens to you, because we're all going to die someday. Spoiler alert. But it's really important to have that inventory so that nothing gets lost. And this is something that's really personal to me. My grandfather passed away in 2001, and my parents did the best job that they could to try and collect all of the assets, but they weren't aware of some Unisys stock that he owned at that time. And now today, they're still trying to collect it from the State Department of Unclaimed Property. And it has been very difficult to collect that asset now because it's been so long. And it happens. And it's part of that $700 million here in Minnesota in the Minnesota Department of Unclaimed Property, unfortunately. Oh, this is really cool. So you can make your living trust a real treasure chest for your kids. And what I mean by that is you can build in asset protection for them that they could never get themselves. So asset protection is a concept where you can protect assets from things like divorce, from things like creditors in a bankruptcy, but it's not something that you can really do yourself. There are some attempts at building first person, it's called, asset protection trusts in places like Nevada and Alaska and South Dakota, where the rules are more favorable about these types of trusts. Unfortunately, in Minnesota, it's just not possible to do those types of first-person asset protection trusts. It's just very difficult. First person means it's your assets that are going into the trust. If it's your assets that are going into the trust, well, then they're accessible from your creditors. That's just the fact of life. That's just how it works, unfortunately. But when you give your kids an inheritance, or when you give somebody that you love an inheritance, that money is actually third person money that's coming to them. It's money coming from another source. And so you can protect that money that you're giving them from their creditors. You can protect that money that you're giving them from their divorcing spouse, and make sure that it's an inheritance that they can enjoy by building in this asset protection. This is something that not a lot of estate planning attorneys are doing, but it is such an excellent opportunity when you're planning for the people that you love, to give them this kind of asset protection. All right, let's talk about incapacity a little bit. And I know that this is something that's very real to a lot of people, that a lot of people have had experience with this kind of issue recently. The person pictured here is Terry Schiavo, and Terry Schiavo's case isn't recent. Her case occurred in the mid-2000s, Terry had a cardiac event and was suffering in a vegetative state, or was in a vegetative state where it wasn't clear how much Terry was able to interact with her surroundings, but she was being sustained by nutrition fed through a tube in order to sustain Terry Schiavo. And her parents wanted one thing for Terry. They wanted her to continue to be sustained on this life-sustaining treatment. But her husband at the time didn't think that Terry would want to live like this, and wanted the life-sustaining treatment to be cut off for Terry. And that would cause Terry to pass away. And there was this huge fight It went all the way up to the Supreme Court. There was a lot of conflict, a lot of court cases about it, lots of money spent, and it was eventually decided that the husband was in the right. They cut off the nutrition, and Terry did pass away. And unfortunately for Terry, she didn't have a healthcare directive in place that was very specific about what her wishes would be. And so everybody was guessing. Everybody had to guess. Her parents had to guess. Her husband had to guess. Her husband was the one who ultimately got to make the decision. But it was a very difficult case. And I see somebody saying her case is used in medical ethics case classes, and that's exactly right. That her case is really widely known now. And I remember living through it in the mid 2000s and hearing about Terry's case and everything that was going on. I also have another question here. Is the asset protection from divorce creditors only because the trust owns it and the original trust creator is the owner and hasn't died? That's a fantastic question. Actually, the original trust creator at that point will have died and will have handed that asset on in a trust to their heir, to the person that to their heir, to their devotee is really what the person is called, or beneficiary. They've handed it on to their beneficiary at that point. And because the creator of the trust put the asset into the trust, and then it eventually went to that beneficiary, it's protected from the beneficiary's divorcing spouse or the beneficiary's creditors. It doesn't immediately protect the asset from the creator of the trust, from their creditors, but when the creator of the trust passes away and it passes on to the heirs, it's protected from the beneficiary's divorcing spouse and creditors. Yeah, that's it is that cool. It's that neat of a thing that you're able to give as a gift to your heirs and to your beneficiaries. It's a really neat thing. So you're probably wondering, we've talked about a number of different things. We just talked about incapacity planning and who can make decisions for you if you can't make those decisions for yourself. If you're in a vegetative state, who gets to decide whether nutrition is kept going, what kind of healthcare is provided to you, where you're living, and all of those types of things. And we've talked about probate and the cost of probate and the public nature of probate. We've talked about estate taxes, and estate taxes don't apply to most people, but if they apply to you, it's very important to plan for those. We've talked about unclaimed property, making sure that if you have an inventory that's written so that your loved ones know where to find your assets if something should happen to you. And we've talked about guardianship. If you have minor kids, how important guardianship is to get in place for them, short-term and long-term guardianship. So you're probably asking, what can I do today to do the right thing for my family, and what should it cost to plan right? And really your options to start with are either do it yourself or work with a lawyer. And do keep in mind, not all lawyers are the same. So how do you choose? Would you benefit from working with a lawyer? If one of these bullet points is true, you would probably benefit from working with a lawyer. If you own more than just your personal belongings, things like cars, clothing, jewelry, furnishings, if you own a house, if you own significant financial assets, there's actually a threshold, $75,000. If you own more than $75,000 worth of assets, or if you own real estate, your estate is going to have to go through the probate process after you die. And so in that case, I would argue you probably would benefit from working with a lawyer in order to try and make sure that you are able to avoid probate for your loved ones after you're gone. If you want to ensure that the people that you love stay out of court and out of conflict and have someone to turn to when something happens to you, you really need to work with a lawyer. You need to work with somebody who can be that person that they can turn to when something happens to you. If you want the kids protection plan, which includes that short-term guardianship, long-term guardianship, medical power of attorney, and instructions to guardians to tell them exactly how you want your kids raised in your absence, or if you want to avoid probate or estate taxes, or you want to protect your children's inheritance in something like that asset protection trust, then you really have to work with a lawyer. Those are things that a lawyer is needed to do. And if you want to guarantee that your plan is going to work when your family needs it to work, and you really need to work with an attorney. And I like to tell this story about a do-it-yourself project because, at heart, I'm really a big DIYer. I believe in doing it yourself, and I've built my fair share of IKEA furniture and all of that. But the story that I tell is my son and I were going to go fishing, and we had two new rods and reels that we needed to put fishing line on. They shipped without fishing line on them. And so I put fishing line on the first one and everything seemed to go okay. And I set the second one up and I put fishing line on it. And as soon as I clipped the fishing line after putting it on, that fishing line just started jumping everywhere off of the reel. I don't know if I wound it. I still don't know exactly what I did wrong, if I just wound it the wrong way or what it was, but I had a mess of fishing line on the table, and it was all wasted. But at the same time, it was probably less than $1 worth of fishing line that I lost and that I had to cut off and start over and start fresh from. Not that big of a deal. And I knew immediately that I had failed in my mission of putting fishing line on that rod and reel. I knew it immediately. I was able to see it that no, something went wrong here. I need to fix this. I need to get this. I need to get this working. And I was able to get it working. I was right there and I was able to fix it, get it working. My son and I were still able to go fishing that morning. So that's an example of a do-it-yourself project that went wrong. But guess what? Nobody was really hurt. The costs were minimal. I knew immediately that it had failed and I was able to fix it. With an estate plan just isn't like that. The costs of failing on an estate plan or getting it wrong can be astronomical. It can be so severe to have to pay those costs. And it happens after you're gone, after you're not available anymore to clean up the mess and to take care of things. In fact, you won't even be aware if your estate plan worked after you're gone. And that's kind of a scary thought. It's not something that you should have on your shoulders, wondering if the do-it-yourself plan that you put into place is actually going to work, which is why I really strongly encourage, and I know that I'm biased, I'm an estate planning attorney, I know that I'm biased, but the costs are really high of getting it wrong, and the risks are really high of getting it wrong, and you're not going to know whether it went right or wrong. You're not going to be able to clean it up after the fact if something goes wrong in your estate plan. And just an added bullet point there, if you want to give your assets to someone other than your kids, again, that's what the state thinks that you want to have happen. If you want to do something different with your assets, then you really need to work with an attorney to make sure that you get that done exactly correct. I see somebody is asking a question, and I'm just going to hold on to that here for a minute as I go through and describe what working with an attorney is like. And I want to bring us back to this quote that came from earlier in the presentation. Someone has to graduate at the bottom of the class. Not all attorneys are the same. And how do you choose an attorney? How do you make sure that you have an attorney who is going to take care of you in a way where you're not left saying, well, somebody had to graduate at the bottom of the class, the way that my parents said about the estate planning attorney who helped my grandmother before I was licensed as an attorney, by the way. This was not said about me again. Really what they were frustrated with is the model that this estate planning attorney was practicing under. And it's really the traditional estate planning model. I call it planning for death. And this is the typical experience. You have form documents, which are kind of set it and forget it documents that they just fill your name in a few different places. And you put it in your desk drawer. You probably don't understand it very well as the attorney is going through it because they've just sized you up for the form document that they think is going to do the right thing for your family, but they're not asking the right questions to find that out even. That's the typical experience. Typical experience isn't going to keep money out of the Minnesota Department of Unclaimed Property. It's just not something that most estate planning attorneys see as in their realm or as necessary for them to deal with and to make sure that they get right. The typical experience probably isn't going to keep your family out of court and out of conflict. It's only going to focus, it may avoid probate, but it may not. Oftentimes that's where we were failing at that small estate planning law firm. And it was really hard to see that we weren't keeping people out of probate when we really could have and should have if we would have helped them with the funding and made sure to follow up and make sure that they kept their funding current and that everything was truly into the trust. It's probably not going to keep the family out of conflict. It's only going to focus on money, not your stories and values. Those are things that I capture through a process called the Family Wealth Legacy Interview. And that's a third meeting that we have together where we do that interview. It's a really neat process, but we're able to capture your stories and pass those on. And I know that oftentimes those stories and values are even more important and even more valuable than passing on your assets to your heirs. Typical experience is going to leave assets to heirs unprotected. Most estate planning attorneys aren't doing that asset protection for the next generation. You're also not going to have ongoing legal guidance because they're going to want to charge hourly fees for any future needs. And that's just not a good way to have a relationship form between attorney and client. It's really important that you're able to approach your attorney and ask them the questions and ask them, I just had my first grandchild was born. Do we need to update things? Or we just moved into a new house. Is there something that we need to do? Is there something that we need to know? You need to be able to communicate with your attorney. And when you're getting billed and you're getting dinged with hourly fees, you're not going to want to pick up the phone and call your attorney because it's just not a good way to operate. And typical experience is not going to adequately protect kids. You'll likely have the long-term guardianship, but probably not the short-term guardianship, probably not real clear instructions to your guardians or anything like that. You're really going to be left with this question. Again, the same question that you had in a DIY situation. Is this going to work when I need it to work? And again, that's not a question anybody should have after they've done estate planning. Planning with me is totally different. It's a totally different experience. I call it planning for life. And the way that I charge, I have flat fees where you actually choose the fee. And that doesn't mean that I'm just reliant on your goodwill to choose a fee that's going to keep food in my kid's mouth or anything like that. But I have different fee packages. And together we'll figure out what your family needs. And you really drive that conversation. And we'll balance between what your family needs and what your finances say and what fits your finances best. Planning with me, it means keeping your money out of the hands of the state. I create inventories for my clients of their assets, and I hold those inventories and make sure that the beneficiaries and that the fiduciaries, the people who need to have that information, have the information after you've passed away. Planning with me is going to protect your kids totally in the immediate and in the long term. Planning with me keeps your family out of court and out of conflict. Planning with me means that you're going to know that you've made the right decisions because I believe in empowering and educating my clients and bringing them along every step of the way. I have information about the laws and about the legal ramifications of things, but you're the one with information about your family and the family dynamics and what's going to work from your family perspective. We really have to work together. We really have to have a relationship where I can educate you about the law and you can tell me what that means in your family dynamic and what's best for your family situation. You really need to design your estate plan with me, but not have it just written from a form for you. Planning with me means protecting the family money from outsiders. That's talking about that asset protection trust that we can build in. And it also means a lifetime of guidance and protection. So included in the flat fee is future communication with me, because I believe it's so important that we keep a relationship, that we're able to continue communicating with each other without hourly fees bogging down our conversation and causing you to be hesitant to reach out to me. If there are changes to your plan in the future, unfortunately, I can't include all of that in the upfront flat fee. Otherwise, it's just not something that I can plan for. There might be changes in your life that you're not anticipating. There might be changes in your life that I'm not anticipating. And so at that point, if there are changes in your plan, we'll agree on a reasonable fee to make the changes. But again, we have word processors. It's not unapproachable to make those changes to your plan. And planning with me just means that you're going to know that your plan is going to work when your family needs it to work. It's really a gift that you're giving to the people that you love the most, that you know that it's going to work. So let's talk about expenses. Let's talk about cost. And I want to give you all this information here so that you have a good feel for exactly what you can expect to spend. Just a little context ahead of time. This planning will save your family at least $12,000 if all you have is a house that's worth $400,000. Again, I know for a lot of people, it's a pretty nice house, but it's pretty realistic nowadays with the cost of real estate. And that's just 3% of that $400,000 house, bringing that through the probate process will cost at least $12,000. More likely, it's going to be towards the higher end, towards $24,000 to get through the probate process. If you have assets in excess over $3 million, and I know that this doesn't apply to most people, but if it does, we can plan for estate taxes, and we can save your family 13 cents on the dollar for every dollar in excess of that $3 million amount. A typical death plan with a typical traditional estate planning attorney is going to cost an absolute minimum of $1,500. It's just, they're not going to do it for any cheaper than that. And if they're doing it for cheaper than that, then they're really cutting some awful corners that you want to be pretty suspect about what they're doing at that point. And for that $1,500, you can be almost guaranteed that it's not going to keep your family out of court and out of conflict. It's not going to ensure that your assets don't end up with the State Department of Unclaimed Property. It's only going to cover your money. It's not going to address your kids' immediate care, nor your values, insights, stories, and experience, those most valuable intangible assets that are the most often lost assets. The alternative is you can meet with me, and I'm a personal family lawyer. You can learn specifically what your family needs and choose your own fee. And my fee range is between $2,000 and $8,000, with most people falling about $4,000. I would say that that's where the average plan is for me. And you're going to know that your plan is going to work when your family needs it to work. And again, I want to make this really easy for you. I'm going to go ahead and share a link here in the chat so that everybody can see it. It's up there on the screen. If you feel comfortable with technology and you feel like you can scan the QR code and get it on your phone, you can do it that way. If you're already on a phone, it makes it a little harder to scan it for the QR code. But there, I just put the link into the chat. That's the link to my calendar. And you can see there, if you click on Family Wealth Planning Session, you can see what my calendar is going forward. I don't have any other time available in August. September is starting to get a little bit picked over, but there's a lot of availability yet. And you can see even more availability in October and November. But I want to give you some things for free. I want to give you $750, the Family Wealth Planning Session. I want to give you that absolutely free. It has a value of $750 because it's a 2-hour-long meeting where we talk about your family and we talk about your assets and we talk about what you would want to have happen. Who would you want to make healthcare decisions for you? Who would you want to make financial decisions for you? Where would you want the assets to go? And how would you want it to happen? And I bring my legal experience and my legal knowledge to the conversation to tell you exactly what would happen right now under your current plan. If you have a plan that's already written, I'll interpret and tell you what that plan says. If you don't have a plan written, then I'll tell you what the state's plan for your assets is for you. And I will just lay it out for you. I'll lay out what happens to your kids. I'll lay out what happens from an estate tax perspective. We'll talk about everything in that Family Wealth Planning Session. Again, it's a 2-hour-long session. It can be done totally virtually. In fact, that's really how I'm doing them right now, over Zoom. And we can meet. And for the first hour is educational, and we really go through and we talk about exactly what the state's plan is for you and what you want. If you want to continue and you want to write an estate plan with me, then we get into actually designing that estate plan and designing your trust if you want to trust, or designing the provisions of your will if you want a will, in the second hour of that Family Wealth Planning Session. And we can really draw everything out and get started on writing an estate plan that is custom tailored to your family and your family's needs and the way that you want your family to be taken care of. So that's the Family Wealth Planning Session. Again, that's a no obligation meeting, and I want to give it to you absolutely free for being with me here tonight. The other thing that I want to give you is $250 towards the estate plan of your choice. And again, I have different plan packages that I offer. I want to give you $250 towards the plan package of your choice if you choose to plan with me. But in order to secure that $250, you need to schedule your Family Wealth Planning Session before the end of the week. And that means the end of the day, Saturday. So I really encourage you to click through to my link and find a time that works for you, that works for your partner, that is going to be a good fit, and that you're going to be able to have that conversation. It doesn't have to, the family wealth planning session doesn't have to happen before the end of the week. You just have to be on my calendar before the end of the week. You just have to find a time that's going to work for you before the end of the week, whether that's in September, October, wherever is the best fit for you. But I want to give you that $250 because this is a momentum thing. And you're here tonight, you're educating yourself on estate planning. You are taking time to educate yourself and learn about this. And I want you to keep the momentum going. And this is something that is really useful that I help a lot of my clients with, is keeping the momentum going so that we get an estate plan done and written, and that nobody loses that momentum moving forward. If you don't book an appointment before the end of the week, unfortunately, what I've seen happen is this falls off of your to-do list. Estate planning, it's too easy for it to fall off of your to-do list. Nobody thinks they're going to die next week. Nobody thinks that they're going to die in a year. It just seems outside of the realm of possibility. And so it gets relegated to the bottom part of our to-do list. But I want to help you keep the momentum going. And the way to do that is by incentivizing you with $250 towards the plan of your choice. It also helps me because it means that I have to do less follow-up with you in order to get you to that family wealth planning session with me. So I really want to give you those gifts. That family wealth planning session, absolutely free, no obligation. I just want to have the conversation with you and kind of give you my knowledge and set your mind at ease. And then if you choose to plan with me, that $250 towards the estate plan of your choice. So next steps. The next step is click through on the link, scan the QR code, book your family wealth planning session with me, and use that $250 towards the plan of your choice. And I want to answer here because I've had a question sitting now for a while. My apologies for letting this question sit for so long. They see, in reference to real estate, what is the benefit of a transfer on death deed versus a will, or versus, it says a living will, but I assume that it means like a last will and testament. And that's a really fantastic question. A transfer on death deed is like a beneficiary designation on a house. It allows that house to pass outside of probate. And so oftentimes, I've done a lot of planning with revocable trusts for people, but revocable trusts aren't always necessary. Sometimes we plan with a transfer on death deed. It depends on how you hold your assets. And there have been plans where we've been able to avoid probate using a transfer on death deed instead of a revocable trust. But the difference between a transfer on death deed, you can avoid probate because the house is immediately going to go to whoever you name as the beneficiary. A will has to go through the probate process in order to get the house to the person that you want it to go to. So it's really, that's the difference, is if you are just making the designation on the house, if that's your only asset and you're trying to make sure that that goes to a specific person. If you do it with a will, that person is going to have to go through probate in order to collect the house. If you do it with a transfer on death deed, they can collect that house without having to go through the probate process. There are just a few documents that they file with the recorder in order to collect that house. Okay, so you know your next step. I hope that you're clicking through and checking. A few questions that I often get. I mentioned before that estate planning is for people who are young, people who are 18 and older. And there are some documents that I really recommend if anybody has kids who are just recently grown, who are going to be going to college this year. I really recommend that you make sure that they have a healthcare directive in place and that they have a power of attorney in place before they go to college or before they go out into the world. And the reason for that is, you might be surprised to hear, but if your 18-year-old ends up in the emergency room, you aren't going to be called. If that child doesn't say, you need to call my mom and dad, then you're not going to be called, and you're not going to have a right to access their healthcare information. You're not going to have a right to find things out and to be there and take care of them and make sure that they're receiving the care that you know that they need to receive. So it's really important that you have a healthcare directive, or that they have a healthcare directive written that allows you to access that healthcare information, that makes their designations about what they want for the healthcare, and that also names you as a healthcare agent in order to be there and help make healthcare decisions on their behalf so that that's very clear. 18-year-old, you're not a minor anymore. You're an adult. You get to make your own decisions. And one of those decisions is if you haven't made a healthcare directive, well, then there's a court process called guardianship in order to get into a position where you can actually have somebody make those healthcare decisions. But that court process is unnecessary. Just get a healthcare directive done. Power of attorney is important if they have utilities and that kind of thing that need to be paid, but they're in the hospital. Power of attorney will allow you to write checks on their behalf and make sure that those things continue to get paid and that the bills continue to get paid. Let's see. I'm not seeing any other questions right now. Does anybody else have a question that they want to make sure that I get to before we close out here? I want to make sure that that you're able to ask that. Something that I'm seeing increasingly is special needs, supplemental needs, and that is a fantastic question. It seems like it's becoming more and more prevalent. With special needs, if somebody's receiving government benefits and they receive an inheritance, they could be kicked off of that government benefit for a time until the assets that they've received are diminished or all spent out. There are certain asset limits, there are certain income limits that apply to people receiving government benefits. And so if it's somebody who has a disability and isn't able to pay for housing or isn't able to pay for food, receiving an inheritance, having that person receive an inheritance can be really harmful because it knocks that person off of the government benefit and requires that they reapply down the road. And there can often be a lapse in coverage or a lapse in before they receive that government benefit. It can really upset their lives. I see here somebody's asking, where can we see this recording? This recording is going to be shared out on YouTube and emailed out to everybody who registered and everybody who attended here tonight. So I will make sure that everybody gets a link to the YouTube of this recording after we're done here tonight. I'm not seeing any other questions, so I'm going to go ahead and call it. My voice is just barely holding on. No, it's not that bad, but I am going to call it here tonight. I want to say that I really appreciate everybody joining. It's been fantastic to have you here. I hope that this has been informational. I hope that you've taken away something here. This is really important. I hope that I've put your mind at ease a little bit. I hope that you feel empowered over this topic. You can take control of this. You can get this done, I promise, and I can make it really simple for you. I would love to make it really simple for you to get a great estate plan in place and to take care of your family in the way that I know that you want to take care of your family. So please click on my link, join me for a family wealth planning session, and we'll get everything really clear and we'll get everything taken care of. Again, thank you for joining me here tonight. I hope everybody has a good night and take care.